I am Sian Smith, and welcome to this, which is our fourth in our second series of remote family law seminars. I'm joined this evening by Francis Custey. He's a family law barrister at 42 Bedford Row, specialising in children matters, and also sits as a deputy district judge. This evening, he's going to be talking to us, giving a private law update with a focus on PD12J and posing the question, should the family courts promote contact? I'm very much looking forward to it, as I'm sure you are too. There's a handout to accompany the talk. It's going to be, or it is, on the 42 website. I will post in just a moment the link into the chat box, and you can download that as the talk is ongoing if you want. And of course, share the link with anyone else from your firms after the seminar. Because of the length of the talk, we're probably not going to be taking any questions live at the end, but do feel free to post any in the chat box or send an email, and I'm sure Francis will do his best to answer them in due course. I will then, without further ado, hand over to Francis to get us started. Thank you.
Thank you everyone for giving up your time at the end of a hard day. It's much appreciated. I'm hoping this talk won't be too dry. You will see that you should see a PowerPoint display on the screen, and I'm hoping now you see the outline for the talk. Is there a duty to promote contact? I'll be spending a lot of time on practice direction 12, talking about strategies and some new case law, considering the reform proposals, looking at vulnerability, which I'll argue is increasingly important, looking at section 9114, which might be subject to proposed reform, looking at some other significant cases, lockdown, and the area that I think is particularly important, which is committal and enforcement. The duty to promote contact was set out eloquently in a number of cases the beginning of the last decade. Re C 2011, Lord Justice Mumby said that contact was a fundamental element of family life. Is almost always in the interest of the child, and only to be terminated in exceptional circumstances where it will be detrimental to the child's welfare. And even a cursory examination of those words will remind all of us that we operate in a much different environment now, where in the cases that comes before the court, there's often a considerable question mark over whether contact should take place or should be promoted. In the current version of Hirschman and McFarlane, referring to Q&Q, a private law case decided by Lord Justice Mumby in 2015, the following proposition is quoted with approval. It's almost always in the interest of a child to have contact with a parent. A rejoinder to that dicta came in Re HW, a 2017 case, where the Court of Appeal said that contact shouldn't take place at all costs, and the obligation on the court is to make a decision with the child's welfare as paramount consideration, weigh up the pros and cons, and see the benefits and the disadvantages. We're all used to working with practice direction 12J now. The basics are well known to all of us. It's an explicit change in the court's approach to the presumption of contact, sets out required practice where domestic abuse is either alleged or admitted. Its general principle, which everyone will of course sign up to, is domestic abuse is harmful to children and it puts them at risk of harm. The difficulties come in how it's implemented. It requires the court to identify the issue of domestic abuse early and establish a process of determining the issue. Part of my approach in this talk is to argue that in fact practice direction 12J is very often inadequately argued. Practitioners don't refer to specific paragraphs and subparagraphs. One has general submissions which sometimes are inaccurate, and I'm urging practitioners to present focused arguments and relevant evidence that addresses the individual parts of the practice direction. One of the decisions that's faced at an early stage is whether it's necessary to conduct a fact-finding hearing, and often that's hotly contested. The person who is accused of allegations might not wish for there to be a fact-finding hearing, particularly because they'll be advised on the delays in the courts. It can sometimes take 5 months to get to a FHEDRA, and then if we're heading for a fact-finding hearing, it's 7 or 8 months after that, perhaps, till you get your fact-finding hearing. And even then, there might be further delays. Paragraph 17 is where practitioners should focus their arguments. There's a whole number of subsections there. In my view, subsection F and G, the ones that talk about relevance and the nature of evidence, and subsection H talks about necessary and proportionality, are important. And it's helpful from my point of view for practitioners to actually include those paragraphs in their position statements, address the judge on them specifically, and also to bear in mind paragraph 19b, which asks whether it's necessary for the fact-finding to take place at a separate and earlier hearing than the welfare hearing. One case where it went wrong is F versus G. It's a 2020 case. There was argument for FHEDRA about whether there should be a fact-finding hearing. The judge was sceptical. Another withdrew her application for a fact-finding hearing. The CAFCAS officer carried out Section 7 report, sought to make findings in the report about domestic abuse, went to a final hearing. The judge made findings based on CAFCAS. Father appealed, and the Mrs. Justice Judge said that she thought the judge had got it wrong, that there hadn't been the proper safeguards. Underlying, there didn't appear to be any way in the balance of harm had it. Underlying that whole appeal was the unfairness of proceeding to fact-finding without procedural safeguards normally included if you have a fact-finding hearing. Interim contact. Those who are used to arguing matters at this stage will know the difficulties faced by parents who aren't having contact or are subject to allegations. Paragraph 25, whether there's a risk of an unmanageable risk of harm is the most important, but addressing paragraphs 26 and 27 is something that is often overlooked. The subsection was the subject of a case called A versus C in 2018. Her Honour Judge Atkinson said that it didn't involve a presumption against contact. And in fact, the practice direction was subservient to the statutory law, which was welfare within the Children Act. I'm not sure that still stands given the importance that's attached to practice direction 12J, but it said there wasn't a presumption, and practitioners can say that and raise that as arguments in favour of interim contact. There are a number of practical steps that can be taken in raising arguments about interim contact. If one's looking at whether there's a risk of unmanageable harm, it would help to do some research in advance about contact centres, other forms of supervision. If there's relatives you want to put forward, get a statement from them, seek permission to file it, see if they're prepared to offer undertakings to make sure they supervise or deal with handovers and don't allow parents to discuss matters that might be harmful. Going back a stage earlier, prepare your client for the CAFCAS interview in terms of the matters that might be raised. Set up for the judge a history of beneficial contact that has taken place earlier. If you're arguing that contact shouldn't take place in the interim stage, well, there's a whole number of bits of the practice direction that will assist you with that, particularly paragraphs 25 onward, and a statement from your client explaining why interim contact shouldn't take place and why it might be harmful will also help the judge to come to a fully considered decision. M versus F 2020 is an example of a case where an interim contact order was overturned. It was overturned because in that case, the trial judge or the judge dealing with the interim hearing is on a Judge Tolson QC, was said to have made an order that was excessive, but importantly within the judgment, Mrs. Justice Judd, who ordered contact to take place in an interim stage, set out the task that she considered Practice Direction 12J imposed on the judge at an interim stage, and she was satisfied that arrangements could be in a child's best interest and the harm could be managed when the father had moved out of the family home. There'd be no recent incidents reported and safeguarding checks had been completed. So that's probably your best authority if you're trying to argue that interim contact can take place safely. Another important part of Practice Direction 12J is paragraph 19 that deals with the evidence to be obtained at a fact-finding hearing. Again, my experience at a header is sometimes parties haven't considered in advance what kind of evidence might be relevant, and that leads to directions being given which don't get all the relevant evidence before the court. Think about all the third parties who might provide evidence. Social services and police are obvious. School might also be a helpful port of call. Think about the witnesses who might support your client's case. Outline to the court at the FHEDRA what information they can bring and gain permission to file and serve statements. The FHEDRA is an occasion when one should be looking at support for those who will be giving evidence. We'll consider that in more detail when we look at vulnerability and pre-hearing reviews. Again, from my perspective, are pretty much always helpful. Repeat 2020 is a case on similar fact evidence, which again exposed the lack of thought given to the evidence to be obtained at an early stage. The mother in that case had wanted to adduce evidence of what she said was strikingly similar coercive and controlling behaviour by father. The trial judge excluded that evidence. Her appeal was allowed. And interestingly, within the judgment, the judge gave a judgment on propensity, which said that in summary, the court must be satisfied on proven facts, propensity is being proven, but the proven facts that must form a sufficient basis to sustain a finding of propensity do not to be proved to the civil standard on each individual item of evidence. Interesting decision. I'm not sure it would survive a challenge to the Court of Appeal on a re-B basis, but at the moment you can obtain propensity evidence on the basis of that authority, and even if each individual item might not come up to the civil standard, in combination they might be enough to establish propensity. Fact-finding hearings dealt with by paragraphs 28 to 31 of the practice direction. They rarely give a clear guidance to the court on how it should approach its fact-finding exercise. They say that the court should then look at whether a Section 7 report should be ordered, and when it has made findings of fact on disputed allegations, any subsequent hearings should be conducted by the same judge. Anyone experiencing these proceedings knows how difficult it is to achieve judicial continuity in private law proceedings. It doesn't attain the priority of care proceedings. There may be good reasons for that, but practitioners should do their best to insist on judicial continuity. We all know the benefits that provides for the case. There's nothing worse than having to go before a new judge when you know another judge knows the case backwards. Another fact-finding hearing that led to an appeal, this one attracted a lot of attention this year, is on a Judge Tolson QC, dealt with a fact-finding hearing that dealt with allegations of rape. He made findings that were very much criticised by the judge who dealt with the appeal, Mrs. Justice Russell, The judge found that the mother hadn't been sexually penetrated without consent because she'd not physically resisted. That finding attracted justified criticism and outrage. But a feature of that appeal was done on a whole number of procedural matters, including asking mother to give evidence from counsel's row behind a screen when the judge couldn't hear her properly, referring to the feng shui of the court, describing mother as neurotic without medical evidence of the same. The appeal was allowed on all counts. It's a reminder that although fact-finding hearing appeals, we are told, are looked down on the Court of Appeal. They don't like to interfere with trial judges. The trial judges don't deal with the case properly and make outlandish findings, then successful appeals can be brought. Rea Child 2020 dealt with how the court should deal with oral evidence in the light of Guestmin and other authorities. Guestmin is a civil commercial authority that says that the court should look to the documentary evidence rather than oral evidence. In this case, the Court of Appeal did find the judge who had found that poisoning had taken place based on mother's recall of events 7 years past, had inappropriately placed reliance on aspects of the mother's oral evidence. And the Court of Appeal also found the judge was in error, reaching a conclusion in respect of the father's alleged motive. Interesting part of that case is what I view as the court's guidance on the importance of oral evidence. The court said that oral evidence could be important, but it was only one factor to be considered amongst all the other relevant factors. There's been a lot of discussion this year about demeanour. There was a care proceedings authority where Leaving J said that she didn't think that demeanour would often be a good guide to truthfulness, and that led to some academic and other arguments about whether demeanour could be relied upon at all. Importance in the context of remote hearing. It's a factor. It's to be considered in relation to all of the other evidence. It will be case specific based on the circumstances of the case, but any arguments that demeanour isn't important can and should be resisted. It's one factor amongst the totality of the evidence. And some of the guidance we received in the light of the beginning of remote hearings is that remote hearings couldn't take place where dishonesty was likely to be a feature of the hearing. But we probably all have experience now of remote hearings going over several days where the court has made very clear findings about honesty or dishonesty, and with the process of time, it appears that things have moved on. Coming back to the practice direction, paras 32 to 34 are guidance on what should happen where domestic violence has been found or admitted to occur. There's a burden on the court to take steps to obtain information about facilities. When the court's considering any form of contact, it has to consider whether it be assisted by social work or other assessment of a party, or whether the party should seek advice or treatment. And activity direction may also be appropriate. The most common activity direction, of course, is a domestic violence intervention or domestic abuse perpetrators program. Those are intensive programs. There's not many of them around at the moment post-lockdown. What we do know is that when findings are made, and the court doesn't consider it can make findings of safe contact, that there will be a long wait for someone against who findings are made, and that they will be subject to the rigours of an intensive and sometimes unforgiving assessment. Paragraphs 35 to 37 of the practice direction so that the factors the court should take into account determining whether to make a child arraignment order where domestic abuse has occurred. Again, this is just my perspective, but very often the individual paragraphs aren't argued before the court, and paragraphs 35, 36 and 37 are all important. Paragraph 37 contains a detailed checklist, and if one is arguing either for or against contact, it's my view that one has to descend into the detail the practice direction, make relevant submissions that actually deal with the specifics of the practice direction. You will see, if you look at paragraph 35, contact order must be in the child's best interest. So not even a neutral contact order, not even one that doesn't cause any harm, but that's in the child's best interest. There's plenty of stuff for anyone to get their teeth into when making relevant submissions. One then looks at paragraphs 38 to paragraph 40. Paragraph 38 is that court should be satisfied that direct contact is safe and beneficial. The court should consider what directions are required to enable the order to be carried into effect. Then looking at supervision and other matters, again, far relevant evidence, if you can, about supervision, the benefits or disbenefits of that. And then the court has to consider whether to order indirect contact as well. And the court's under a duty to set out how its findings have influenced its decision. If the court doesn't fulfill that duty, well, one should ask the court for clarification, and it may indeed find a ground of appeal. On the 19th of January, the Court of Appeal is going to consider, I think it's 3 or 4 conjoined appeals about Practice Direction 12J. When I first heard about that, I was hopeful the appeals would shine some light on the inner machinery of Practice Direction 12J. Now, having found out a little bit about those appeals, I think they're going to be appeals about how the court deals with findings of rape, and when the court has made findings, how it approaches the issues of contact. That's only because I've heard Mr. Justice Cobb talk about the appeals in general terms. It may be that they deal with the practice direction more specifically than that. But in any event, once the Court of Appeal judgment is available, our plan at 42 Bedford Road is to send out a bulletin that sets out the what has been decided in the judgment and any points that are of assistance to practice. It will be interesting to see whether and to what extent the decision of the decisions to be made by the Court of Appeal are influenced by what's now come to be referred to as the harm report. The harm report is a wide-ranging challenge to how the courts deal with issues of domestic violence under Practice Direction 12J. The report suggests, in effect, that the system isn't fit for purpose in terms of protecting victims of domestic violence and abuse from harm. It suggests that the child arrangements project needs to be redesigned to some effect. It suggests that there should be a completely different and new culture of safety and protection from harm. And it also suggests that there should be a review of the presumption of parental involvement in section 1(2)(a) of the Children Act 1989. It's not a comfortable read for anyone who's involved in the system at the moment. And I would also direct practitioners' attention to a contribution from Lorraine Kavanagh QC to a recent Family Justice Council forum about the talk. She explained how she had found her involvement in the harm review to be challenging to her. She advised practitioners to tidy up their own backyard. That was the words that she used in relation to vulnerable witness measures, in relation to using publicly available specialist domestic abuse and sexual offences resources, particularly those arising from the criminal jurisdiction. And in relation to the use of Scott schedules, it's one of the recommendations of the harm report is that Scott schedules are an inappropriate form, and the reductive effect of taking allegations down to the 5 or 6 that the applicant is asked to choose is not helpful, particularly when dealing with allegations of a course of conduct of coercive control or emotional abuse. Vulnerability is clearly, it seems to me, an issue that is under addressed within private law proceedings. The fact that someone is making allegations of domestic abuse brings them within the definition of vulnerability in Part 3A of the Family Proceedings Rules and in Practice Direction 3AA. That imposes on the court a duty to make relevant participation directions. It imposes a duty on all parties to raise the issue where it's obvious. And there are anyone suffering from a significant physical or emotional or mental disability comes within the definition of vulnerability. It's very unusual to see ground rules hearings, in my experience, in private law family disputes where there are allegations of domestic harm, and any consideration of the family procedures rules in the relevant parts will remind practitioners that actually it should be a commonplace experience. Supplementing what's set out in the family procedural rules was the President's guidance on safety from domestic abuse and special measures in remote and hybrid hearings. The guidance is set out on the government's website. It can be easily Google searched. I've sent out a summary in the handout and in the slide of the matters that the President brings to people's attention. It's really a direction for everyone to take stock in advance of what kind of environment is available to parties at a remote hearing. People can be accidentally brought into view of the camera. Litigants who would not normally be brought into contact with each other can be brought into contact with each other at these hearings. And it's the President's guidance with some detailed information that checks should be taken to make sure that those kind of occasions simply don't happen and that litigants are protected from that. And he's amplified that in his recent edition of the Road Ahead. Another of the harm review's recommendations is that Section 9114, either in how it's drafted or in how it's implemented, should be the subject of reform. In fact, when one looks at the plain words of the subsection, it should be a flexible tool that judges can use when considering their judgment, when they've heard all the evidence, when they're considering the facts in the case. Do they think that there should be an order that no application can be made without the permission of the court? Re-N 2019 case reminds us that in fact the stipulations or safeguards set out in case law have actually brought around a much different regime. In Re-N, we're reminded of the old guidelines from Re-T 2015 that the parties need to have full knowledge of the evidential base on which an order is sought, have a proper opportunity to make representations, and there should be an adjournment if necessary. So one might expect there to be some reconsideration of how Section 9114 works, simply because so many litigants end one set of proceedings and then start another set, and judges are reluctant to make Section 9114 orders. Another Re-N or a Re-P&N from 2019, Mr. Justice Cobb sets out how applications to begin proceedings, for permission to begin proceeding, should be dealt with. Essentially, his guidance is that applications should be considered on the papers at first instance. Decisions should be made then about whether to have a hearing with the applicant only present if it looks like it's a no-hoper. If the application without merit can be dismissed at that stage, the other party doesn't need to know. But if there is an arguable case, then there should be an on-notice hearing at which the respondent can be present and make representations. I think the difficulty has been that sometimes respondents only become aware that permission's been given after the event, where they're faced with a whole new set of proceedings. One judgment that gained some traction and attention was His Honour Judge Wildbird's judgment, the necessary private law applications. It may well be that judge does get overwhelmed with unnecessary private law applications. He talked about micromanagement, but in fact, in that case, he was dealing with an application for disclosure of the mother's medical records. In my experience, they're always difficult applications. On the one hand, there's the considerations of privacy for medical records. On the other hand, there's the common experience that sometimes medical records give rise to significant and relevant information. But in any event, it gave him a platform to complain about all of the micromanagement cases he has to deal with, such as which service station handovers should be dealt with. And indeed, one can see in some of the communications from the president that he shares a similar view, and it may be that one of the reforms, that applications should be dealt with in different tiers within the private law sphere, might gain some traction in the years ahead. FF versus BM is a classical case report where unfortunately the magistrates got things badly wrong. Final hearing, the issue was whether a child arrangements order for spending time should be made. The magistrates decided to only hear evidence from the CAFCAS officer and to make a finding about the father's immigration status to the effect that his immigration status was uncertain and therefore it would be wrong to restart contact with a risk that it might soon come to an end. His Honour Judge Moutreuil dealt with the appeal. His judgment effectively said that the magistrates had got pretty much everything wrong. He made it plain their task was to consider all of the relevant matters within the statutory checklist, which they had not, and that appeal was successful. RES is a parallel alienation case, which again gained a lot of attention this year. I would direct everyone to the two excellent talks given by Sharon Batju of 42 Bedford Row, both currently available on the 42 Bedford Row website for a detailed consideration of parallel alienation. This case gained a lot of attention because it dealt with a cult. In my view, the most important consideration of the case is how the court should deal with transfer of residence cases. Mr. Justice Williams gave the judgment in the High Court, and he made it plain that they're not simply to be a matter of last resort. They are based on paramount welfare consideration and necessity and proportionality. In that case, he found the mother hadn't sufficiently distanced herself from the cult of universal medicine, and he ordered the transfer of residence. Another 2019 case, again, His Honour Judge Wildblood, dealing with a parental alienation case, gave a checklist of matters that could be considered so that the issues in parental alienation cases are considered at an early stage. There's been a plethora of checklists put forward by judges in the last couple of years. I wasn't quite aware of how many until I researched this talk. Know that this is a helpful checklist. It's essentially a call to identify the issue early, to list an early fact-finding hearing, and then to make sure that professionals are working together. How much of that is achievable? How quickly one can get to early intervention is open to question until there's been an effective fact-finding hearing. But that's a case that one can raise to persuade a judge that parental alienation should be dealt with by directions from very early stage of the proceedings. Towards the end of 2020, a vaccination case and versus age gained a lot of attention. In many ways, there's a standard vaccination case dealing with a dispute over whether the MMR vaccine should be administered to a child. The father supported vaccination, the mother opposed. The court, as will be no surprise to most practitioners, decided vaccination should go ahead. essentially what the courts say is vaccination is peer-reviewed and approved by the relevant health authorities. The court's likely to order vaccination. There was also a decision to be made about COVID-19 vaccination, which may become a live issue this year. The judge didn't deal with that then because it wasn't at a stage where the vaccination had been fully approved. The judge gave a heavy hint that an approved COVID-19 vaccination is likely to be administered to children by order of the court if necessary, if there's a dispute between children. Father versus mother, another 2020 case. This is a case that involved travel abroad. The facts are broadly that mother wanted the children to live in England, father wanted the children to live in Dubai. They'd lived in both countries. It was eventually accepted the children should live in Dubai by the father. And there was then an issue about whether the father might take the children on holiday to Dubai. Dubai is not a Hague Convention country, and the mother was concerned about that. The judge put in all the safeguards possible to make sure that if the father sought to retain the children, that the court in Dubai would order that, including a parental agreement about the same. However, the judge accepted there was only a 70% chance such an agreement being upheld by the Dubai courts, but nevertheless made an order that father could take the children to Dubai. As a side note to that case, the courts have been overwhelmed by the amount of holiday cases in the run-up to Christmas that arose. Parents who have shared care are disagreeing about holidays because there's a quarantine period when children come back. Again, just applying my experience, but when the holidays are split, if a parent wants to take a child on holiday, he or she has to include it in that holiday the quarantine period on return, which was 5 days in the run-up to Christmas. There's no higher court authority. I can't see the courts making substantially different decisions about that. Relocation, there was a 2020 case. It was another case from Mr. Justice Williams. He reinforced the judgment he'd set out in EWHC in 2019, i.e. that we're essentially dealing with a welfare-based decision. He set out another checklist, which I've set out in summary. You're welcome to consider in more detail. He referred to as an FKC Payne Composite. So welfare is the main consideration, but it is open to parties to introduce economic arguments in as much as they affect welfare. You should keep it for reference if you're involved in a relocation case, but it's clear now that the welfare is the prevailing consideration, and Payne issues only come in insofar as they affect welfare. Lockdown, another checklist, this time from McDonald J about remote hearings. It's the latest. Mr. Justice McDonald didn't only give us a checklist about the factors to be involved, which went to 9 factors. Then when he got to factor 9, he set out another 12 factors in a sub-checklist. Keep that case to hand until there's a new one. If you're dealing with arguments about whether there should be a remote hearing, and they're inevitable within the months to come, then those are the factors that you draw to the court's attention. And it seems to me within those factors, the factors could be used to include either a decision for an attended hearing, a hybrid hearing, or remote hearing. But those are the factors that you need to bring to the court's attention. I'm very conscious that this talk is quite dry, and it's always traditional that there's one more curio case that's included to lighten the mood. District Judge Wiley attracted some attention towards the end of the year because District Judge Wiley dealt with a fact-finding hearing, made 2 findings, and then recused herself from the case because her son and the mother were members of the same hockey club and they'd followed each other on social media. The case therefore came before His Honour Judge Duggan, who felt that because the independent observer would consider the judge couldn't hear part 2 of the case, then they shouldn't have done part 1, set aside the findings. That was brought to the Court of Appeal, and the Court of Appeal said the correct question is whether a neutral observer would consider that there was a real possibility that the judge was biased There was no evidence to find that District Judge Wiley would have been biased in this case. So the findings were put back by the Court of Appeal, and the matter was remitted. I can only think that District Judge Wiley had had enough of that case, whatever reason, and decided to have no more to do with it. I'm going to finish by talking about committal issues and enforcement issues because they are vital in relation to child arrangements orders if the other parent simply decides they're not going to go along with the child arrangements. Andreewitch versus Moutreuil is another case where the applicant appeared to have a very good case on committal, but because of what appeared to be one procedural defect, not being informed by the trial judge, the alleged contender not being informed by the trial judge of his right to silence, the committal was overturned by the Court of Appeal. And that reminds me of the large number of cases within the family jurisdiction where committal applications had been unsuccessful. In 2018, Mr. Justice Baker, as he then was, in CH versus CT, set out in a very detailed judgment the different procedural requirements in relation to enforcement applications relating to Section 11J of the Children Act and committal applications, which involve Part 37 of the Family Procedure Rules. On any reading of the judgment, the road to committal is so difficult procedurally that it should only be considered as a matter of last resort. Section 1112, Section J of the Children Act sets out the procedure for enforcement. Within his judgment, Mr. Justice Baker set that out in considerable detail. And I've copied into the handout a lot of that judgment because it gives, in my opinion, the best procedural guides to the competing routes. Very importantly, in CH and CT, another case of a failed committal application, the procedural requirements under Part 37 of the Family Procedure Rules and the Practice Direction 37A are onerous, rarely completely complied with, and give a very real steer to what I would regard as the imperative of going down the enforcement route first. Even in relation to enforcement, it's important to ensure that any child arrangements order contains a wording in the correct form. It should be applied by the court in relation to any child arrangements order, but all practitioners will know that it's unwise to rely on the court sometimes to do those very basic matters. The warning is set out in the latest version of the template orders, which can be downloaded from the court service website. The warning notice for committal is in some respects more technical, but what I've done is set out the different warning notices from the standard orders. What the standard orders have done is firstly given one warning notice relating to enforcement and committal all in one, and secondly set out a warning notice to be directed towards a particular individual. They're set out in the handout. You can see in under slide 39 the warning notice for a penal notice addressed to a particular individual is set out on a belt and braces approach. Apply for that if you're worried about someone not complying with child arrangements order. It's a matter of judicial discretion though that's slightly counterintuitive because the standard warning, as I already said, contains a form of a penal notice in any event. Thank you very much to everyone for bearing with me through this talk. I'm sorry it's been a little bit dry and a bit of an information download. Practice direction 12, make the most focused submissions you can, obtain the relevant evidence, vulnerability, consider it in all of the cases, and watch out for the Court of Appeal decision and the bulletin that we will provide. Chamber's next talk will take place in 2 weeks' time. It will be delivered by Sean Smith, who I'll now hand over to. It will deal with vulnerability, fairness, and the remote family court. Sean Smith has led the way in making provision for vulnerable witnesses within the FLBA and beyond, and I have no doubt that that will be a very valuable talk. Once again, thank you for bearing with me. I'll hand back over to Sean.
Thank you very much, Francis. A really interesting talk on all matters private law. If you haven't already, you can download the handout from the 40TBR website. The link is in chat box. You just have to scroll down to the download section. There's 2 downloads. You can download the PowerPoint and the handout. As well, the seminar will be available along with all our seminars on the Chamber's YouTube channel, and it should be there after today. I think we've had one question so far, which I'm sure Francis will deal with by email. So perhaps if you're that person, just ping an email to the Chamber's website address and we'll get back to you. And then, yes, please join us in 2 weeks' time for our seminar. It will be myself and intermediary Nicola Lewis will be talking about vulnerability in the remote family court and sharing some of our thoughts and hopefully some tips on dealing with that. Thank you very much for coming along this evening, and we'll see you next time. Thank you.